is Irena Domaradzki. Can somebody tell me how to pronounce that?
Domaradzki.
Domaradzki versus Michael Dennis. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. It's my understanding the bailiff explained that even though there's a cross appeal, you still have to use your allotted time to argue all of those things. I also understand there's a motion pending as well. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims in your arguments. Please refer to them by initials or terms like the child. We've read your briefs and we're prepared to proceed when you are.
Thank you, Judge Lenzinger, and if it pleases the court, I'm Edward Herman for the appellant Mike Dennis, who is with us in the courtroom today. I would like to reserve 6 minutes in rebuttal.
You can only reserve up to 5.
Thank you, Judge. 5 minutes, please.
You got it.
So this case involves a man and a woman, Mike and Irene, who were engaged and then purchased a house. Briefly to go through the timeline, they dated for about 10 years prior to 2010. In 2010, they were engaged. Mike gave Irene a ring. 3 years later, they decided to purchase a home together. It was decided that Irene would be the sole title holder and the mortgage holder because Mike was involved in civil litigation at the time. In 2014, Mike moved in as intended and lived there with Irene. They lived there together. They were clearly a romantic couple. Then sometime in 2015, Irene kicked Mike out, broke off the engagement. Then sometime later, while Mike wasn't living there, he began making payments to Irene towards the mortgage. And he continued to do so until early 2017 when he discovered that she had another romantic relationship, the man who would eventually become her husband. From 2017 to 2022, the former couple remained at odds about what to do with the house. We agreed we were going to purchase it together. It isn't working out. What should we do? Then in June of 2022, Irene attempted to sell the home out from under Mike. Mike brought suit, and here we are today. When Mike brought suit, he brought an oral contract claim and equitable claims. The court at summary judgment threw out the oral contract claim saying it was barred by the statute of frauds. The case went to a bench trial on the equitable claims where there is no right to jury, unlike the contract claim that had been disposed of. The magistrate found in Mike's favor on the equitable claims to essentially the maximum amount that the theory of unjust enrichment allowed her to award. He maxed out his award there. The essence of the appeal here is simple. Mike believed that the pleadings and the facts established in the discovery were sufficient to establish that the doctrine of partial performance or part performance should have taken the contract out of the statute of frauds if it belonged there in the first place. He doesn't think it did, but even if it did. Why? He contributed towards the down payment, he conducted repairs, and he obtained possession of the property.
What was the contract, this oral contract, what was it for?
The oral contract was an agreement that the house would be used and co-owned as marital property, Your Honor.
What is that the key, marital property? Doesn't that imply that under Tripp v. Frank in those cases, this was in contemplation of marriage?
I look at that jurisprudence as having to do with dowry and coverture. So if you look at the Hodges case, there's a phrase in there that talks about settlements in contemplation of marriage. I think that pretty clearly referred to what are those settlements that referred back to a time when property moved with a woman when she was married from her family to the husband, and it became his property upon marriage.
But our Tripp v. French case didn't seem to dwell on the fact that this was the old style dowry and that sort of stuff. It just said, look, there was an agreement. You're saying there was an agreement to do certain things when you got married. And that means it's a contract in contemplation of marriage, and that means it has to be in writing with statute of frauds. And this isn't in writing. And there's no partial performance because the partial performance in those cases means there has to be a marriage. that becomes a partial performance.
But I think that's the confusion of the two distinct pathways presented in Hodges. If we look in Hodges, it talks about the classic elements of court performance, or alternatively, settlements and contemplation of marriage. So I believe that's the correct course.
But I'm trying to figure out what your contract is. I mean, you file a complaint, you folks say, here is the contract we're trying to enforce.
Right,
So when I read your complaint, I read it as, these people were going to get married, so they bought the property together, and this was done in contemplation of marriage. That's your phrase of the contract, not mine. And you're saying that's what our contract was.
I believe, well, so if we look at the statute of frauds and its understanding of real estate law, we have, on the one hand, sales agreements, and we have, on the other hand, leases. This is neither. I think this could best be categorized as a use agreement. One of the issues here is people don't do it the old-fashioned way anymore. It was almost unheard of 25 years ago that first you get engaged, then you buy the property, then you get married. It's in a different order. The jurisprudence goes back to a time where it would have been essentially unlawful for a man and woman to live together in a house when they weren't married. So I think the answer is it's a use agreement. I don't think it actually belongs in the statute of frauds.
Well, then what was the use agreement? Specifically referring to what was the use agreement? At some point in time, she says leave, he says, okay, it's her house, is that the violation when she says leave?
I think that's the breach.
And that occurred in 2015.
Correct.
And at that point in time, what would the statute of limitation been for that cause of action? When the breach occurred in 2015, or their use agreement, hey, we're gonna use this property together.
If the breach was in 2015, I think, I don't know, the law changed right about that time. It was either 6 or 8 years.
Well, there could have been a statute of limitation problem if it was 6 years, that would have had to been considered.
I think that's right. I think there would be an issue there.
Can you tell me why this isn't moot? Considering that there's been a judgment, it's been paid, the ring has been returned.
Yes, Your Honor.
Why is this not moot?
So if we look at the case law presented by the appellee, it's clear that if the trial court loser pays, the trial court loser cannot appeal. It's moot. The judgment's unsatisfied.
So in this case, would you say the cross appeal is moot? They're the loser, they lost, they paid. The cross appeal, they're different actions, your appeal and their appeal.
I think that's right, insofar as the appellee was the trial court loser, a judgment was entered against her in a manner, and she paid it. I don't think she can appeal that. I think that's right. But back to your question, Judge Lanziger, Mike's the trial court winner. So the trial court winner is not stopped from saying that the award was too low, because it wasn't tried under a contract theory. Under a contract theory of recovery, the jury would not have been limited by the unjust enrichment principles, which are essentially you just get what you put back in.
So if there's an escrow account and you're planning to appeal because you've lost in some form, wouldn't you have a duty to ask for a stay of the disbursement of the escrow?
I don't think so, because I'm dealing here with the winner, not the loser.
But you're not the winner if you're making an appeal.
Well, he won the award in the trial.
No, I
court.
understand the award, but
Right.
obviously he feels he lost in some fashion here.
I don't think you feel he lost. I think you feel he wasn't able to present a contract claim. So that the satisfaction of that judgment has been filed in the trial court, and clearly, if this case is sent back for a trial on the contract claim, the trial court would have to adjust any jury award by that amount. It's been partially paid. That he acknowledges that. That's the essence of it. The essence of this is we don't believe that contract belongs in the statute of frauds, because it's neither a sales contract nor a lease agreement. It's a use agreement. But if this court says that it is, then all three elements of the doctrine of partial performance have been satisfied. This was not an agreement in contemplation of marriage insofar as it's understood in the case law. It wasn't about a dowry. It wasn't about a transfer of chattels from the wife's family to her husband's family. It didn't have anything to do with that. This is a modern situation. So I think the trial court declined to invoke any of the gifts in contemplation of marriage jurisprudence, because I suspect they believe what I believe, that it's arcane, it's obsolescent, and it refers back to a time when women didn't have full legal rights. And that's why the jurisdiction was presented in the first place.
Counsel, what are you claiming your damages would have been if the court had proceeded under contract?
I believe, Your Honor, the jury would have been able to make award of what percentage of the net proceeds of the sale of the house Mike was entitled to
So in equity, basically?
in contract. I think in equity.
No, I'm saying the equity in the house when it was sold.
Yeah, that's right, Judge, yes.
In
But-
contract that they would each get 50% because they're married, they would be dividing it as if they were married, I mean, what are the terms there?
How would the jury decide it?
No, I mean, what would you argue would be the calculation?
I think the calculation would have to do with essentially determining what the profit was, subtracting each party's inputs, and then dividing it evenly.
But if he just had a right to use the property, why does he get to share in the profit? If he just has a right to use the property, and that's what you're saying the contract was, I have a contract to use this property, it doesn't make him an owner, why is he getting to share in the profit from the sale?
Part of the essence of the oral contract, Your Honor, is that the two would eventually hold it jointly and would hold it as marital property.
I think
Again-
you're calling marriage,
Back to marital property.
you're calling marriage, old fashioned, but the point of marriage is that you have certain protections when you're buying assets, but you don't have those protections. If you didn't get married, somebody bought the house and had the house, then that contract law applies, right? Contract law applies, it doesn't apply.
I agree completely. The question here is whether or not this agreement, given all the elements of part performance were met, was excluded by the statute of frauds.
And he did recover in an equity type of fashion with unjust enrichment.
I would say he recovered in part.
You're in your rebuttal time, just let me.
Okay, thank you.
Hey, please the court. Good afternoon. Christopher Mulvaney, counsel for Irens Domaradzki, appellee in Cross Appellants. I think this court has hit the nail on the head as far as the discussion of mootness. The underlying judgment has been fully paid and satisfied, and the trial court has entered an order saying that it has been fully paid and satisfied. At this point, we believe that Mike is effectively trying to recover twice, recover the same damages in a unjust enrichment claim that he's also seeking to recover in a contract claim. If this court finds that the contract claim should have proceeded, then we should not have proceeded to trial on the unjust enrichment claim. And now we'd have to effectively unwind that entire transaction. Mike would have to return approximately $40,000 that he has received as part of the sale of the property.
Well, your client made a choice. Your client wasn't required to make those payments. She could have asked for a stay. She didn't. She chose to make the payments. She now has a satisfactory judgment. Under blood God wouldn't make that her cause of action moot. Regardless of whatever that cause of action is going on, her cause of action is moot.
I would think that both appeals are moot at this point. I think mine is probably moot as well, but we cannot unilaterally disarm and dismiss our appeal while there is still pending, waiting to see what this court would do. I think we need to protect her rights to potentially hold, as far as the argument, especially with regard to the statute of limitations, to protect her interest there. I think that the argument that has been made about trial court winners versus losers doesn't really truly address the case law and the express language of the civil rule. Civil Rule 62B, the stay on appeal rule, does not mention winners or losers. It mentions an appellant.
It says aggrieved party. So you have to have an aggrieved party. And he's saying I'm aggrieved because of the fact that I wanted to proceed under a contract and I would have been entitled to more damages, and the court only instructed the jury on unjust enrichment, or the jury only came back on unjust enrichment. I'm not sure exactly what happened.
So this was a bench trial.
Okay,
The parties met ahead of trial and both agreed to waive the jury.
okay,
So it
that's
had
fine.
been set for a jury, but it was only a bench trial.
In my recollection is that there was a motion for summary judgment on the breach of contract that was granted. So
Correct.
that didn't go to the trial, and the trial was just on the unjust enrichment, is that correct?
Trial was solely on the issue of unjust enrichment. But I believe that it's,
So you're saying that he didn't preserve it through his summary judgment?
the initial claim was lost in summary judgment. My position is that if you wish to preserve the contract claim, then the appellant, Michael Dennis, was obligated to move for a stay to stop my client from complying with the judgment in this case. And she was ordered by the court to create a constructive trust for the part of the house to be sold, for him to receive his money, and for the ring to be returned.
When the summary judgment decision was made, was that a final order that appellant could appeal at that point in time?
No, Your Honor. That would have had to wait until the final conclusion of the case. But that's why if he wanted to stop it from being satisfied, it was up to appellant to ask the court to stay enforcement of the judgment. And
I'm still trying to figure out how he's not aggrieved.
I think he was aggrieved by not being able to pursue his claim for under contract. It was lost in summary judgment. And if he wanted to stop the judgment from being satisfied, I still believe he was obligated to move the court for a stay of the judgment.
Is this similar to a person is this similar to like foreclosure where you don't request a stay and it's property sold?
I think that's exactly correct. Same.
Except
Even if
there
you're-
is a loser.
Yeah.
You're going back to the winners and losers, I'm sorry.
Well, if you're, I think, I guess the question is he aggrieved? And obviously if you file an appeal, you thought you're a loser in some form.
But I guess my primary opposition to the use of the framing of winner and loser is that I don't see that in any of the case law, and I don't see that in the civil rules. The rules just say appellant. The appellant can seek a stay. And here, the appellant elected not to seek a stay.
But he would be seeking a stay to keep money from himself.
That would have been a decision that the appellant would have had to make. He would have had to decide, do I want to take the risk that she's going to comply with the judgment?
It sounds almost like you're arguing more accord and satisfaction, quite frankly.
I think the judgment has been satisfied.
That's what I'm saying.
I
It's more
think-
like you're saying, well, since he went ahead and took what was awarded to him, then therefore the judgment is satisfied, no matter if he had other avenues of recourse that were not awarded to him or not.
I believe,
So if we reverse this, hypothetically speaking, everybody would have to give back the money that was in escrow, and the ring would have to go back to, so is mootness about live controversy here? And
I believe so, Your Honor. There is no more live controversy in this case. The satisfaction of the judgment, and especially the trial court's entry of an order, which has not been appealed in and of itself. In fact, my motion to have the judgment satisfied is not even opposed by counsel. So the only thing that we can conclude is that the judgment in this case is satisfied, rendering it moot. To the extent Judge Carr made reference to accord and satisfaction, we may be able to make that argument with respect to the escrow instructions that were signed by both parties and copies which were previously submitted in the briefing, where he acknowledged his right to receive the $39,557.55 plus 8% interest, which totaled out to about $40,042 and some cents.
So what you're saying is, even if, since he sued under contract as well as unjust enrichment, since he was only awarded under unjust enrichment, you can't have an award under contract and unjust enrichment. So everything would have to be returned, and he may not get as much money under the contract claim.
I would agree, Your Honor. I think we would have the same issues with the statute of limitations. We can restart the case and start arguing again over statute of limitations on contract for that case.
So a bird in hand is worth two in the bush?
I would think so.
I don't know, I'm just asking.
I think that Ultimately, we would have a number of serious issues if the judgment was overturned and the contract claim was allowed to continue. As you mentioned, we would have to unwind everything in this case.
Well, let's look at the contract claim. What, in your view, is the contract they're alleging exists in this case?
I think that Mike was very clear when he filed his counterclaims and the affidavit of facts that this was to be a home that they would jointly use as their marital residence. That was the argument that he made right from the very start of this. Every bit of contribution that was made was in contemplation of marriage, and the home was intended to be the marital home.
So therefore, you would say the contract and contemplation of marriage and our trip in those cases apply?
Correct, Your Honor. I think that it was clearly done in contemplation of marriage. Michael Dennis has clearly stated multiple times that everything he did was in contemplation of marriage. The trial court's decision found that it was in contemplation of marriage. And it's a little difficult for me to see him now coming and saying that it wasn't truly in contemplation of marriage. There was some other set of deals or agreements.
Was there any dispute of fact below? In other words, this is summary judgment motion. Are we dealing with disputed facts, or just here is what these facts we all agree exist? What is the law based upon these facts?
I don't believe there were that many facts in dispute. The bigger question was interpretation of the facts. Everybody agreed when they bought the house. There was agreement that the relationship ended in May of 2015. There was agreement that he made payments to Irena in 2016 and 2017. There was no real dispute of facts as to that. But, let's see. I think that Your Honor was on point with identifying the Tripp and the French cases, Nazi Flynn, Trippy French, with regards to gifts and contemplation of marriage. I believe that as far as our appeal goes, the court erred in not finding that they were barred by the statute of limitations. The engagement ended in 2015. The trial court determined that the cause of action accrued in 2022 when Irena signed a contract to sell the property. I think that all of the case law regarding gifts and contemplation of marriage clearly indicates that the cause of action accrues when the engagement ends. To the implications of the trial court's decision that the cause of action accrued in 2022 when she elected to sell the house creates a number of issues. First, it would raise the issue of there are now potentially people with interests in real estate that are not recorded anywhere. There's no record of it. His claim that he had an actual interest in the property by virtue of the money that was contributed. How can any title company going forward have title insurance with clear ownership of the property? Because we simply will not be able to tell whether there is an aggrieved ex out there somewhere who will pop up and say, I have an interest in this property. Will that interest attach to future buyers? In this case, if Irena never sold the house, under the trial court's decision, Michael Dennis could never have recovered any of his money. Because according to the trial court, the cause of action accrued and the statute of limitations began when she signed the contract. If she simply lived there for the rest of her life, there is zero avenue for Michael Dennis to be able to recover any of the money he ever contributed to the property. Now we run into some fun issues of what if she lives there until she dies? Does Michael have the ability to sue her heirs? What if 50 years from now, when both of them have passed, are his heirs going to be suing her heirs when they try to sell the house? There has to be a definitive guideline of when the cause of action accrues. And I think that Nazi Flynn, Trippy French all make it very clear, including that they dealt with real estate, the cause of action and the ability to sue to recover the money begins when the engagement ends. Period, full stop. For instance, does the trial court's decision that the cause of action accrues when you elect to sell, would that apply to an engagement ring? Our office has handled multiple cases where a ex-fiancé will file a replevin action for the return of a ring after an engagement ends. If the cause of action will only accrue when you try to sell the item, does that mean that they can't sue to recover an engagement ring until somebody tries to sell it at a pawn shop? I think it's very clear the trial court erred in finding that the statute of limitations did not begin the moment that the contract ended. I think that council made a large deal out of the holdings in Desai v. Franklin to hold that the manifest unjustness accrued when Irena went to sell the house. I think that is not the proper model to look at this case. That was an employment action where Desai, the plaintiff, simply did not know he was effectively being cheated by his former employer until after he left. Here, Michael Dennis was fully aware that the relationship ended. There was absolutely no question that in May of 2015, their engagement ended. And at that point, he was entitled to receive back any contributions he made in contemplation of marriage. And as mentioned, he has alleged in his counterclaim, in the affidavit of facts, it was found by the trial court that all gifts and all contributions that Michael Dennis made were done solely in contemplation of marriage. There was no other contract, there was no other agreement. This was gonna be the house they were gonna live in when they got married. As far as the statute of frauds argument goes regarding the use agreement that counsel is referencing, I don't think that that argument should stand in this case, largely because that's not what Michael Dennis said. That's not what he alleged in his complaint. And that's not what he alleged in his affidavit of facts or at any point through this case. He alleged that when they bought the house, that was when he acquired his interest in the property.
And you're out of time, so if you could wrap up in 15 seconds, thank you.
So I believe that your honors had already hit the mark on identifying the problems with gifts in contemplation of marriage and issues regarding this case so far. Thank you very much.
We'll have about 4 minutes for rebuttal.
Thank you. I think the trial court very wisely avoided the whole question of gifts in contemplation of marriage when it relied upon equitable principles and employed Franklin v. Desai. And I think, perhaps Desai v. Franklin, and I think this court should do the same thing. I think settlements in contemplation of marriage, in the language is Hodges, is not what we're talking about here. What we're talking about there is Farmer Jones is going to give some acreage to Farmer Johnson when Farmer Jones's daughter gets married to Farmer Johnson's son. That's where that comes from. I think it comes out of a time of dowry and coverture. The trial court didn't settle the case that way, and I don't think it should be used. It's dizzy. If you look at the case law, there's at least 5 different approaches used by the Court of Appeals. But I would like to conclude in just talking for a moment about what happened in the trial court and just bring it to this court's attention. The summary judgment ruling stripping out the contract claim came down 3 or 4 court days prior to the jury trial. When that happened, well, I should say, before that happened, my colleague and I had a complete set of jury instructions ready to go. We were completely set to go. We incurred the cost. The court handled summary judgment in such a way where there was no jury demand left. When there's no jury demand left, the judge doesn't have to hear the case. It allowed the court to kick the whole matter to its magistrate. I would say that under contract law, all 3 elements of partial performance are satisfied. And I don't like the thought that one of the oldest and most sacred rights that we have, the right to trial by jury, enshrined in the Constitution, would be sidestepped 3 days before the jury trial under conditions that allow the magistrate to hear the case, and thereby, as a practical matter, save the court some time and effort. Thank you. If there are no questions, I'll conclude.
Thank both for your presentations. The court will take this matter under advisement and issue a ruling in due course. Also, the court will mail you a copy of the decision on the day it's released, and our decisions are posted on the Ohio Supreme Court website. Thank you again.